and we expect around 85 to 90% of those companies to be held by New Zealanders, including the government's 51% share, once the share offer has taken place.
Question number 2, Charles Chauvel.
Thank you, Mr Speaker. My question is to the Attorney-General and asks, were the prosecution guidelines dated 1 January 2010 applied to the decision not to prosecute Mr Ambrose over the T-tape complaint?
The Honourable Chris Finlayson.
Mr Speaker, the decision whether or not to prosecute was an independent decision made by the Police Commissioner. I have no personal knowledge of the Commissioner's process in making his decision. There is no day-to-day supervision of prosecution decisions made by agencies, including the police.
Point of order, Mr Speaker.
Point of order, Charles Chauvel.
Mr Speaker, the prosecution guidelines make it clear that the Attorney-General is responsible for their administration, and I thought it was perfectly within the ambit of my primary question to ask the Attorney whether he was satisfied that on this occasion they had applied. That's what the question does.
Well, I think within it's the Minister's answer was a reasonable answer, I believe, because the member asked whether the prosecution guidelines statement were applied, and the Minister described exactly what happened. The member can dig deeper with his further supplementary questions. I think it would be unreasonable for the Speaker to say that was an unacceptable answer. There are more supplementary questions. That the idea of the supplementary questions to dig into the Minister's answer. Did the process, given the information about the Police Commissioner making the decision independently, did that process meet these guidelines? And that's what supplementary questions are for. Charles Chauvel.
Thank you, Mr Speaker. Supplementary question to the Attorney-General. Given that paragraph 1.5 of the prosecution guidelines clearly state an expectation that they will apply to decisions relating to prosecution by the New Zealand Police, is he satisfied as Attorney-General that the prosecution guidelines were properly applied in this case?
The Honourable Chris Finlayson.
Speaker, the decision about whether or not to prosecute was an independent decision made by the Police Commissioner. There is no day-to-day supervision of prosecution decisions made by agencies, including the police.
Point of order, Charles Chauvel.
My supplementary question on your advice, sir, sought the view of the Attorney-General as to the appropriateness of the decision made on this occasion, given that he is the officer of the state responsible for the application of the prosecution guidelines. It's perfectly proper for him to express a view and to answer the question.
Well, here the Honourable Chris Finlayson, the Attorney-General.
Would it be not right for me, it would be quite improper for me to make any comment second-guessing a decision by the Commissioner in whether or not to prosecute. There is a clear delineation between the general principles set out in the guidelines and day-to-day matters.
Interesting issue that has arisen. The question that Charles Chauvel has asked does not ask about the merits of the particular decision for which the Attorney-General is not responsible. The question asked is whether the Attorney-General is satisfied the guidelines applied. The guidelines are something the Attorney-General is responsible for. And I think while the Attorney-General is quite right that he's got to be careful not to comment on particular decisions by the independent authority, the Police Commissioner, the question is a reasonable question about whether the Attorney-General is satisfied the guidelines for which he is responsible that were applied. And that is not, in my view, a question out of order. And I would invite the Attorney-General to answer that.
Well, I'm afraid I'll probably displease you because I can and will add nothing further to that. This is a day-to-day decision made by the Commissioner, and I am not privy to the Commissioner's thought processes in making the decision about whether or not to prosecute. And I go further than that and say it would be quite improper for me to comment.
Is this a point of order?
Yes, sir.
Charles Chauvel, point of order.
The Attorney-General, either deliberately or otherwise, is missing the point. And you were quite clear in your ruling about this, sir. It was simply a question about whether he had a view as Principal Law Officer of the state responsible for the prosecution guidelines administration in New Zealand, whether or not the decision as to whether to prosecute in this case was sufficiently compliant with those guidelines. He's entitled to have a view, indeed he should have a view, sir.
It's a very interesting situation that has arisen here, and I've got to say I have sympathy for both members because the guidelines exist and the Attorney-General is responsible for them. But I think in his further answer there, the Attorney-General has indicated, although he didn't perhaps use the words, that he considered that it's not in the public interest for him to go further than he has in answering, even with respect to the guidelines. Now, it raised all sorts of interesting issues around the value of the guidelines, but still, the Attorney-General has argued, I'm on my feet, the Attorney-General has argued that he believes, I'm interpreting what he said, that it would not be in the public interest for him to comment further with respect to whether or not that decision complied with the guidelines. Now, I should not second-guess that answer from the Attorney-General. The member is entitled to ask further questions about it, although Charles Chauvel.
Point of order, Mr Speaker.
Point of order, Charles Chauvel.
Mr Speaker, thank you for your ruling. Could we have clarification in the circumstances from the Attorney-General that he is claiming that it is not in the public interest to answer my question? Because if I understand your ruling correctly, that is how you have taken his answer.
Well, I think he made that very clear, that he said he would not comment further on the individual decision of the police commissioner, even in covering that decision in relationship to the guidelines. And that is clearly a decision that he does not consider it in the public interest for the Attorney-General to be commenting on such a decision. I think it's reasonable for me to accept that as Speaker. Point of order, the Honourable Trevor.
Mr Speaker, the normal approach that's been taken in this House, I can remember probably 3 or 4 times previously, is where a minister believes it's not in the public interest to answer a question, they get up and they say just that, rather than they're being interpreted as they are now by you as meaning that, even though they don't say it.
I accept the point the member makes. Would the Attorney-General assist the progress of the House? Would he be prepared to indicate in his view whether in fact it's the issue of public interest that prevents him from
I didn't think
answering
it was some kind of Prima 1 formula.
No, I've asked.
I so do.
He has now declared it not in the public interest. Charles Chauvel, supplementary question.
Mr Speaker, supplementary question to the Attorney-General. Does he have any knowledge of why the decision not to prosecute, was announced only yesterday when it was made at least a week ago, and whether or not the relationship has anything to do with the absence overseas of the Prime Minister, who was the complainant?
The Honourable Chris Finlayson.
As I've already said, it's becoming a litany now. I have no personal knowledge of the Commissioner's process in making this decision. There's no day-to-day supervision of prosecution decisions made by agencies, including the police.
Charles Chauvel.
Thank you, Mr Speaker. Has the Crown agreed, as part of the withdrawal of the Prime Minister's criminal complaint against Mr Ambrose, or otherwise, not to pursue all or any of the costs of defending the declaratory judgment application that Mr Ambrose filed in the High Court last year?
The Honourable Chris Finlayson.
Now moved from the criminal to the civil and is making reference to the costs application made by the Solicitor General under his delegated authority after the decision was concluded. I'm just trying for the benefit of you, the former MP for Waimakariri, to set it out in Prima 1 terms. That matter having been made.
Point of order, Mr Speaker.
Point of order, Charles Chauvel. Order.
Order. I know that the Attorney doesn't like these sort of questions, but he's
order.
not entitled to insult members.
Order. The member will resume his seat, and I'm on my feet, and some members will be leaving this House if that's not respected. Now, the Attorney-General did not help, and it always leads disorder when unhelpful comments are made. And so I think, had it not been for that unhelpful comment, the Minister was answering the question in a reasonable manner, though, and I would invite the Minister to answer the question without the unhelpful comments. The Honourable Chris Finlayson.
Yeah, I don't want to offend Mr.
Just answer the question, please, Minister.
After the decision of Justice Lynn Coleman was released, the Solicitor General filed an application for costs. That has been responded to by counsel for Mr Ambrose. The matter is before the judge. and it would be improper for me to start commenting on those matters in this place. Any decision as to the ultimate outcome of those matters or negotiations are presumably for the lawyers.
Point of order, Mr Speaker.
Point of order, Charles Chauvel.
I'm sorry to do this, sir, but the question was very carefully framed, and the attorney is accountable in this area. He can't answer in a vague fashion like that and avoid the question. It was whether or not there had been agreement between the Crown's lawyers, who are accountable to him, and Mr Ambrose's lawyers about withdrawing the claim for costs in the civil proceedings consequent on the withdrawal of the criminal prosecution.
Order. Forgive me, but I'm not understanding the member there, obviously, because the Attorney-General pointed out the matter is still before the court, and it would be, in his view, I think he made it clear, improper for him to comment on any matters to do with this issue that is before the court, especially in matters to do with any possible agreements between lawyers that may have impact on the decision of the court.
Speaking to the point of order, sir,
Charles Chauvel.
The issue here is a simple question as to whether, as part of the deal to withdraw the criminal prosecution, there was also an arrangement between private lawyers on the one hand and lawyers accountable to the attorney for the other on whether or not to continue to seek costs in the civil case. And there's no reason why the attorney shouldn't answer that question.
Well, Order, I would have thought it very obvious that, the member appears to be making some kind of possible allegation in his question that such an agreement might have existed. Now, clearly the Attorney-General is not going to comment on anything like that because he would consider it, I would have thought, to be sub judice because the matter is before the civil matter is still before the court, and any matter relating to lawyers involved in that civil matter, the Attorney-General, I would have thought, it not in the public interest to answer. In fact, it's beyond not in the public interest. It is a matter that is sub judice, and it would be inappropriate for any member of this Parliament to get into commenting about those issues.
Point of order, Mr Speaker.
A point of order, the Honourable Trevor Mallard.
Mr Speaker, the sub judice rules are for matters which are before the court awaiting adjudication. The suggestion made by my colleague is that this is a matter of agreement and therefore will not be subject to adjudication. The attorney can just say no.
Order. The member's getting into debating this issue. The Attorney-General has indicated to the House the matter is before the court. The Speaker has to accept that. I can't go arguing the Attorney-General, the senior law officer of the land, is wrong when he says the matter is before the court and therefore sub judice. And I have to accept that from the Attorney-General. If the Attorney-General is wrong in that matter, he has to face criticism publicly for being wrong. But I have to accept his view that the matter is sub judice. And just because it may become subject to an agreement between lawyers doesn't make it not sub judice in the meantime. Point of order, the Honourable Trevor Mallard.
Mr Speaker, if a question is sub judice and therefore ruled out from here, it is your decision, sir, and, sir, it is not a decision of the government or their lawyer.
Order. It's a point now. We're not going to have debate across the House. The Speaker cannot have full knowledge of all matters that are before the court. Order. The Attorney-General has a number of advisory roles, and the Attorney-General has made it clear to the House that it is his understanding that this matter is still before the court. As Speaker, I've accepted that, and I'm ruling, therefore, that we shouldn't be raising questions about that particular matter that is still before the court, and that is that civil action that I understand where the matter is still before the court. Supplementary question, Charles Chauvel.
Thank you, Mr Speaker. Does he have a view as Principal Law Officer about the appropriateness of both the prosecuting agency in this case and then the Prime Minister publicly pronouncing on Mr Ambrose's guilt after the prosecution was withdrawn, despite the failure of the prosecution to meet the test for prosecution?
The Honourable Chris Finlayson.
As will be tolerably clear, the answer is no, for the reason that I do not get involved in day-to-day matters concerning prosecutions.
Question number 3, Tim McIndoe.